Feaster on behalf of Mr. Barrage Scott, who is approaching the podium. Mr. Scott, please state your name for the record.
Barrage Scott, sir.
How you doing, Brian?
All right, just glad to see my family in here. That's all.
Thank you, Judge.
Been here every time for you.
Yeah.
All right.
Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report. Scott is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people?
But also stipulate that the defendant is competent.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'll be asking this might be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond for him on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see his prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks that he's asking for potential release.
Response.
I would ask that bond remain as currently set. I appreciate Mr. Feaster's advocacy on behalf of his client. I'm struck by the I think it was in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe. Candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and as
Nothing further, Judge.
All right. I am going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters, and typically I can let Mr. Scott out of custody. He may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not going to take that chance again, especially since this
You understand what he's saying to you?
violent case.
So hold on, do you understand what he said to you?
So
He said that he let you out. This happened a
I
week
understand. I
later.
know, but he keeps saying the same thing.
Okay.
Saying the same thing that he said.
Okay.
It's not.
I believe Mr. Scott wants to address you directly, Your Honor, if you don't.
Go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor saying I was on I wasn't cooperating the correct way, and I was. It seems like I had to take two competency tests, and the first one he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed it like this, but after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. It's my grandma. She's 70 years old, something like that. What it happen if you keep me in here and then she just something
Mr.
happens?
Scott.
No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
what do you mean? Listen, can you just let me
Motion for bond reduction denied. Bond will continue.
Thank you, Judge.
But
Go to
you
that.
ain't let me speak,
Go
though.
to that, Mr. Scott.
You ain't even let me speak.
Thank you, Judge.
As this hearing comes to a close, it's important to step back and understand exactly what just happened in this courtroom and why the judge's decision, while emotional, was ultimately rooted in legal reality. The court had already made one crucial finding at the beginning of this hearing. Mr. Barrage Scott was found competent to stand trial. That means, legally speaking, the court determined he understands the nature of the proceedings against him and can assist in his own defense. This point matters because once competency is established, the court is no longer weighing whether a defendant understands what's happening, but rather what risk they pose if released. From there, the defense made a heartfelt and layered argument for bond reduction. We heard about mental health struggles, medication compliance, family support, willingness to wear a tether, and openness to treatment programs. On the surface, those are exactly the kinds of factors judges are encouraged to consider. The defense emphasized that Mr. Scott's mental state is currently more stable, that he has support from his grandmother and family, and that he claims he will not flee or reoffend if released. Emotionally, it's a compelling plea, especially when Mr. Scott later speaks directly about grief, addiction, and the loss of his sister. But here's where the courtroom reality hits hard. The judge was not focused on promises. He was focused on pattern and history. The judge made it very clear Mr. Scott has been given chances before. He has been released before. And according to the court, he failed to make it even a week before being rearrested, this time on a violent charge involving firearm. That single fact outweighed nearly everything else discussed in this hearing. In bond decisions, especially in violent cases, judges are legally required to weigh public safety above all else. Mental health considerations matter, but they do not override a demonstrated risk to the community. When the judge referenced Mr. Scott's criminal history and prior releases, he wasn't punishing him for the past. He was explaining why the court no longer finds release to be a reasonable risk. That's a critical distinction to Mr. Scott's emotional outburst at the end, where he says he wasn't allowed to speak and accuses the system of making him look bad, only reinforced the judge's concern. From the bench's perspective, this wasn't a defendant calmly accepting responsibility or showing insight. It was a defendant deflecting blame and minimizing the seriousness of the current charge. Whether viewers sympathize with him or not, that perception matters enormously in court, and let's be very clear about one thing. The judge did not deny bond because Mr. Scott has mental health issues. He denied bond because, in the judge's words, he believes Mr. Scott is dangerous based on prior conduct and the nature of the alleged offense. That is the legal threshold, and once a judge reaches that conclusion, bond reduction is almost impossible. So the final ruling stands. Bond reduction denied. Mr. Scott remains in custody. The case moves forward toward a probable cause conference, where the evidence, not emotions, will take center stage. Now, here's the question for you. If you were the judge, would you have taken another chance, or would you have drawn the line here too? Do repeated failures outweigh family support and treatment promises? This case highlights a harsh truth about the justice system. Second chances are real, but they are not unlimited. When public safety is on the line, courts tend to stop gambling. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.